And I would like to invite to the stage Mr. Enrique Tortell and his colleagues from the same law firm, Ulrika Blanz. Mr. Tortell and Ulrika are coming from Frankfurt, and please start your lecture.
Okay, thank you. Okay. So, right. So, good morning, ladies and gentlemen. Thank you for the invitation. I'm very pleased to be here today and just like to give you some background information about the liability rules in Germany. First of all, I want to introduce myself, Enrique Tortell, German lawyer with Spanish roots from Barcelona, so also from the Mediterranean Sea. We have a little law office in Frankfurt and in Bad Vilbel. It's 10 kilometers from Frankfurt. That means in the middle of Germany with 8 lawyers, and we are specialized in advising of national and international small and middle-sized companies. And it's really a pleasure to give you some background information about liability rules in Germany. But first of all, I want to state that I think it's really the right moment for investment in Germany. Why? Germany is passing by a very prosperity period. Last year, we broke a new record, 42 million persons working in Germany. It's a new record. The unemployment rate is less than 5%. The gold reserves in the last years become very high. So the second state after the United States, that means a very prosperous country with rich consumers. And the authorities, the state has a lot of money. A lot of money for what? To make a good law, to give a big protection to the citizens, the consumers, and it's also important to know that in liability rules, Germany implemented all the directives of the European Union. That means that we have high standard in liability, a high protection of the consumers and citizens with a lot of money to spend for interesting also Israeli products. So to start with the question, what does liability for defects mean? We have the Article 433 BGB, in which we have a definition. There we have the wording, by a purchase agreement, the seller of the thing, I would say better the delivery item or the purchase object, but the official translation is the thing. I can change it. So by a purchase agreement, the seller of a thing is obliged to deliver the thing to the buyer and to procure ownership of the thing for the buyer. The seller must procure the thing for the buyer free from material and legal defects. Okay, so what does that mean? What happens if the seller don't fulfill his contractual obligation? Very easy. The purchaser's liability rights apply. But liability for what? For which rights? So we have 2 different rights. We have first the personal injury, what we named in German Körperverletzung, and we have liability for damage to property because of a defective product. So attention, the liability applies equally to manufacturers and dealers. Such persons are liable not only for the consumer but also to each other, irrespective of whether products for private or commercial were involved. Good. So then we go on with the second slide. And there we see that the German legal system knows two different grounds for compensatory liability. The one you see at first is liability resulting from a contract, so the contractual liability. And second, the other one is a liability that is provided for by law, gesetzliche Deliktshaftung, so the statutory liability. And before I speak about the contractual liability, about these two items from civil law, I want to focus your attention on the first point, criminal liability. So beside the distinction of contractual and statutory liability, which are both concepts of the German civil law, be careful with the criminal liability. So Israeli producers and importers should know, in my opinion, that the German criminal code, Strafgesetzbuch, applies when a person's life, body or health is harmed by a defective product. Moreover, if a manufacturer or distributor has learned of danger inherent in a previously undetected product defect and fails to conduct a product recall, criminal liability for any injuries may result. In accordance with Article 39 of the German Product Safety Act, in German the word is Produktsicherheitsgesetz, anybody, that means manufacturer, their agents, distributors, who failed to inform the competent German authorities comprehensively and in timely manner of a product that does not conform to the safety specifications of the Product Safety Act, commits a misdemeanor. In German, Ordnungswidrigkeit. It's not a crime, it's only a misdemeanor. But is also punished with penalty, so with money at the end. If the manufacturer, his agent or the distributor continues to circulate or introduce to circulation products that do not conform to standards of the Product Safety Act, despite knowing of the nonconformity, then they commit a crime in accordance with Article 40 of the Product Safety Act. Criminal liability does not require, also important, an actual injury or harm. So not necessary that the person is really harmed by this defective product. Criminal penalties applies as soon, also important, as a criminal act endanger life, body, health or property of a significant value. Significant value of the property. If body health is harmed, in any case, it's commit the crime. Finally, in reference with criminal liability, it's also good to know that the Safety Act prescribes imprisonment, jail, for anyone who intentionally or continually disregards the competent German authorities' orders, including an order to recall a non-conforming product with up to 1 year. So don't think that now the criminal liability will avoid you of a successful investment in Germany, but I think it's important to know that the security or the protection of the citizens, of the consumers is very high. So then we go on with the next slide. There we have sorts of warranty. So we're speaking here about the contractual liability. For the contractual liability, there are several ways of ascertaining whether a sold product is defective in breach of warranty. And then we have the first category, the express